They said my grandfather's ranch violated a rule that didn't even exist when he built it. Then they sent a letter threatening to seize 40 acres his family bled for. What the HOA board didn't know, I'd spent 6 years writing property law for a living. They were about to learn that the hard way. Before we continue, tell me where you're watching from. Drop your country in the comments. And if you're enjoying these stories, hit subscribe now, because the next one is even more unbelievable. My grandfather bought this land in 1962, 41 acres of red dirt, oak trees, and a barn he built with his own 2 hands before the county even paved the road out front. There was no HOA back then, no committee, no rules except the ones he made for himself. He passed it down to my mother, and when she got sick, it passed to me. I didn't grow up there, not really. I grew up visiting on weekends, learning to ride, learning to listen to a man who believed land was the one thing nobody could ever really take from you. He used to say that a lot. Nobody can take this from you, unless you let them. I didn't understand what he meant until the day I opened my mailbox and found an envelope with a seal I didn't recognize. That envelope changed everything. The letter was from something called the Cedar Hollow Homeowners Association. I'd never heard of it. Turns out, 3 years earlier, a new housing development had gone up less than a mile from my grandfather's property line, and somehow, through a paperwork mess nobody could fully explain, our ranch had been folded into their HOA boundary map. The letter claimed our fencing violated community aesthetic standards. Our barn violated structural uniformity codes. And worst of all, it claimed unpaid HOA dues, going back 3 years, had accumulated into a lien substantial enough to force a legal seizure of the property if not resolved within 30 days. 30 days. To lose land my family had held for over 60 years. I remember standing in that driveway, letter shaking in my hand, staring at the barn my grandfather built board by board. My first instinct was pure panic. My second instinct was disbelief. How does an HOA even have the power to do this? But here's the thing they didn't know about me. And here's the thing I didn't tell them. Not yet. I wanted to see exactly how far they'd go first. I called the HOA office the next morning, calm, polite, just trying to understand. The woman on the phone, I'll call her Denise, because that's not her real name, told me flatly that the board had unanimously voted to pursue foreclosure proceedings if the dues weren't paid in full, plus penalties, plus legal fees they'd already started racking up. Legal fees. For a case that hadn't even been filed yet. I asked for documentation showing how my grandfather's property, deeded decades before this HOA existed, had legally become subject to their covenants. Denise said she'd have someone look into it and hung up. 3 days later, a second letter arrived. This one had a photo attached. Someone had driven onto the property and photographed the barn, the fence line, even the old tractor under its tarp. Marked in red pen, violations. Then came the knock at the door. A man in a polo shirt with an HOA badge clipped to his belt told me, almost cheerfully, that the board had scheduled a vote to approve the lien filing and that once filed, the county would begin seizure proceedings automatically. He said it like it was already decided, like I didn't have a say. He smiled when he said it. That smile is the reason I decided to stop being polite. Because what none of them understood, what Denise, what the man in the polo shirt, what the entire Cedar Hollow board had no idea, was who exactly they'd just threatened. Here's what I hadn't told anyone at that HOA office. For 6 years, I worked as a property law attorney. Not corporate law, not criminal law. Property law, deeds, liens, easements, boundary disputes, HOA, covenants. The exact niche of law that governed everything they were trying to do to my family's land. I'd spent years reading the fine print other people skip. I'd spent years watching HOAs bully homeowners who didn't know their rights, didn't know the statutes, didn't know that most HOA power exists only because people don't push back. I knew exactly what questions to ask. I knew exactly what documents they were legally required to produce. And I knew, within about 90 seconds of reading that first letter, that something about their claim didn't add up. Because an HOA can't simply absorb a property into its jurisdiction after the fact. There are recording requirements. Disclosure requirements. A property has to be legally annexed, on record, with proper notice to the owner. I went digging into the county recorder's office that same afternoon. What I found there didn't just weaken their case, it shattered it completely. The county records showed no annexation filing for my grandfather's property. None. Not in 1962, not in 2005 when Cedar Hollow was formed. Not ever. My family's land had never legally been part of that HOA's jurisdiction, which meant every covenant violation, every dues charge, every threatened lien was built on a foundation that didn't exist. I requested the HOA's governing documents. I requested board meeting minutes. I requested the original boundary survey they claimed included our property. Under the law, they were required to produce these records within a set window. They stalled. Denise stopped returning calls. The man in the polo shirt stopped showing up. So I did what 6 years of legal training taught me to do. I drafted a formal cease and desist letter citing the exact statutes governing HOA annexation, lien validity, and wrongful foreclosure attempts. I attached the county recorder's own documents as proof. I copied the HOA's insurance carrier because boards personally exposed to liability tend to move a lot faster than boards hiding behind committees. Then I requested to speak at their next board meeting. Publicly, they tried to deny the request. Turns out, under their own bylaws, they legally couldn't. I remember walking into that meeting room with a folder 3 inches thick, watching Denise's face shift the moment she recognized my name from the letterhead. She finally understood who she'd been threatening. But the board president still thought he could talk his way out of it. He was wrong. I stood up in front of the full board, folder open, and laid it out piece by piece. No annexation filing. No legal jurisdiction. No valid lien. No legitimate basis for a single letter they'd sent, including the threats of seizure that had kept me up at night for weeks. I told them plainly, if they filed that lien knowing the property was never legally under their jurisdiction, that wasn't just a mistake. That was a pattern that could expose the board and them personally to a wrongful foreclosure lawsuit plus damages plus attorney's fees. The room went dead silent. One board member started flipping frantically through her own copy of the bylaws. Another turned to the HOA's attorney, who was sitting quietly in the back and who, I noticed, would not make eye contact with me. The board president tried to argue procedure. I calmly cited the exact statute that made procedure irrelevant when jurisdiction never existed in the first place. Within 4 minutes, the president motioned to table the lien filing indefinitely. The vote to withdraw it was unanimous. Every hand in that room went up, including his. 2 weeks later, I received formal written confirmation. The lien was withdrawn, the violations dismissed, and the HOA acknowledged in writing that my grandfather's property had never been under their jurisdiction. They also agreed to update their boundary map permanently. I drove out to the ranch that weekend, stood in the same spot where I'd once held that shaking letter in my hands. The barn was still standing. The fence line was still ours. The land was still ours. I thought about what my grandfather used to say. Nobody can take this from you unless you let them. I didn't let them. That ranch is still in my family today, exactly where it's always been. But this wasn't the last time an HOA tried to overstep, and the next story I'm about to tell you is even more unbelievable. Subscribe now, because you will not want to miss what happens next.